Hey, good morning.
Hey, good morning.
I feel like I just saw you.
Yeah.
And did we coordinate? Did we have a conversation? Was a
Hey.
memo sent? What? What the what? How are you this morning?
I'm great in yourself.
I'm good. I'm good. I'm not as sleepy as I thought I would be, but I'm good.
Good.
It's way past my bedtime. And I was still up. Like, girl, go to bed. You got to get up in the morning at 6 o'clock. Go to bed. What are you doing? So, how was your week? I know we already discussed that, but the people
Yeah.
don't know. So, how was your
Yeah.
week?
It went by pretty quickly. I mean, I'm always doing something. It
you
was it
know,
was it was a week. How was yours?
the same. And this weather has just not been cooperating for anybody. We've had just
No.
rain all week. Rain, 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 rain. And trees down, and folks have had power down, and just all kinds of stuff. It's been
Oh
crazy ever since
wow.
Sundays. It started Sunday. It just nonstop all day, every day.
Wow. We had a thunderstorm not last night, but the night before last.
Mm-hmm. I'm like, come on, come on. I mean, I know we need it. I know, because I love the pretty. There's nothing like pretty green spring grass. I think it's just gorgeous. But okay. I think we're good now. No. And let's talk about our experience last night. How was that? Did you
Oh,
enjoy it? I thought
I
it was so
really,
much fun.
really did.
Yes, yes. If you missed it, we were on High Powered, the AHIMA podcast with Dr. Jasmine Agnew, Dr. J, and we had a good time. A good time was had by all. And our tea spiller uh, aficionado was spilling all kinds of tea in the way in which he spills it. So it was a good time had by all. I thought you had a little competition there for a minute, though. I was like, wait a minute, she trying to steal the thunder. Wait a minute, this his role in the podcast world. What's she doing? I was like, fall back, girl, fall back. You don't want none of this. But it was a good time.
It really, really was.
It was fun. It was fun. I like her her energy, and even her co-host. Their energy together is funny. So
And
it,
it was really more discussions like that need to be had
absolutely,
because
particularly from AHIMA.
yes,
From the organization. Let this be organizational led, so people understand, their viewpoint, where they're coming from, and the expectations, of the organization. So I appreciated it.
because I really appreciated what Dr. Jasmine was saying about how she was on TikTok and how they were talking about AAPC and they didn't even know about AHEMA and didn't even know that they were eligible for any AHEMA credentials like that. That's a messaging problem.
Yeah. But
And
it's always been segregated for, it's like, well, which one do I go? Well, why not get both? Which is what I
there you
always tell
go.
my students. Get both. Plant your feet in both areas. Don't don't plant your feet in sink and stand, because some of these other folks, I don't know what they got going on, but plant your feet in some firm foundation in both of the organizations, so that you're prepared. You're prepared for anything at all.
Anything. It was. I'm just looking forward to more because I know Dr. Jasmine's going to have more conversations and it's going
Absolutely.
to, and just bringing more awareness to the organization and how people can find their place in it because it it's good and it's always great to have options. That's all.
Absolutely.
That's
Absolutely.
all we could ever want is
Absolutely.
options.
I got options. Oh, hey, come on, Jamie Foxx, you channeling it. Okay. All right, all right. Well, let's get our party started here. Welcome to our Saturday morning tea. Here we brew up the hottest topics in healthcare. We discuss health information news, education, certification tips, options, and not the financial ones. The coding certification, organizations, the weather, how the week has been weeking, and all of the things, as well as entrepreneurship, and really the revenue cycle at large. Did I hit them all? I think I hit them all today. Yes. So as you come in, don't forget to hit the thumbs up or like button. I'm Clarice Warner. I'm the girl with the pearls, the founder and senior education director of the Professional Reimbursement Network, LLC, where coding education is key. And PRN is a healthcare compliance consultancy located in Cincinnati, Ohio, that specializes in revenue cycle and regulatory compliance and education. And let me ask you, do you know what it takes to be a certified marketable medical coder? Did we talk about it last night? I swear we talked about it last night.
Marketable came up all the time.
All the time throughout the conversation.
And
Well,
certification. So that
and
was
certification. Absolutely. Absolutely. So before I introduce my co-host, let me share with you information on a free, yes, free 99 email course on the 5 steps to become a certified marketable medical coder. Are you interested in medical coding, but not sure where to start? And scared of wasting time and resources? Let me help you with the right steps to become a certified marketable medical coder. Learn more at bit.ly/5stepscoder. Hey, I'm gonna need an extended remix at the end or something. I don't know. All right. So if you are interested in getting more information about the 5 steps to become a certified marketable medical coder, then check out the video description for the link. So joining me today is my partner in success, my co-host, Mr. Jesse, the registered trademark. Put some respect on his name, the coding nurse. Sir, introduce yourself and tell the folks all about you.
Good morning, everybody. My name is Jesse. I live in Philadelphia. I've been in healthcare. I've been a nurse for a long time. In 2014, I left the bedside. Well, I left the bedside before then, but in 2014, I segued into HIM in the realm of risk adjustment and really liked it. So during the pandemic in 2020, I created a company called the Coding Nurse LLC, where I help nurses and other people in healthcare with a clinical background transition into the wonderful world of HIM.
Mhm. All right. Listen to that intro. I heard it. I heard them gems. All right. And how is that going for you?
It's coming along. I have a new ICD-10 CM class starting on Thursday, April 17th at 6 p.m. Eastern Time. And to find more information, visit thecodingnurse.com.
You didn't want to say that for the announcements? I don't know. I just
Oh, okay.
I mean,
You know, it's
you didn't. I mean, I know you see you because when I tell you to repeat it, then you're gonna be like, really?
exactly. Yeah, okay. All right. I got it. All
We haven't been doing this what 153
right.
times. I don't understand. I'm messing.
I think about it all the time, how our situation just came from Clubhouse and just scrolling through, finding these rooms,
Yeah,
and
yeah. And here we are,
yeah,
years later. Like I go back, I'm like, we've been doing this for some years. Wow. And still here, and still so much to talk about. It's just so you see, just seeing that should help you understand how our profession has so many things going on. It's multifaceted. It's always it's constant. It's constant. And while there's always change, it's still very constant. And I can't say that we've ever really repeated anything, in
no,
all of these episodes. I mean, we may dibble and dabble and connect some of the topics, but never had to repeat because there's so much going on. Always.
it really is. It really, really is.
Like sometimes it's like a drama. Like dig in. You never know where it's gonna go. All right. Well, let me just remind you that you can join in and add to the conversation. So don't be shy. Your opinion matters and is always welcomed here. So, friends, use the chat on whatever platform you are on. And if you have a question, please just place a cue so we know that it is actually for us and we don't miss it. I'm preparing and I'm speaking into manifestation for the future when this chat box is just flying and I'm like, oh wait, I need to go back. So let me prepare you for when that happens. How about that?
Absolutely.
So for those who are joining, oh, hi, Dr. Jasmine. Welcome. I don't know what you're asking me, but welcome. Good morning. For those who are just joining us or watching the replay, today we are talking new HIPAA rules protecting reproductive health privacy. When I tell you this is a doozy, this is a doozy. But first, let's get into our church announcements. Shall we? Yes, we shall. Uh-oh, look at you. See, you're ready with that, but don't be ready with the other things, sir. Hey.
It's first Sunday. I'm ready.
And you ready. I love it. Hey.
I'm at the polish.
Go ahead.
I'm at to polish my Stacey Adams for tomorrow.
Have them shining, glistening, gliding in the church. Yes. Somebody was talking about how they are bringing, and they were like, keep those stands outside of the church. But people was bringing their little line dance bands in the church. I said, oh word. But now I've seen that in some of those dances, people are bringing tambourines to the trail ride. Imagine that. And they feeling it. I said, y'all better get it with the tambourine.
It's going to be a concert.
It's going to be a whole concert on the floor. I can't wait to see one. I might have to go to Houston or somewhere just to go look at one from the sideline. Because I'm not getting that. All right. So, let's turn that down. So, good morning, Crafty Coder, our On the Street correspondent. Good morning. So, let's talk about, so I ran into this article from Becker's Pair Issues from Riley Wilson. And our friends over there at the United Health Group, I don't know who they know and who they may have paid in any of those things, allegedly, but they fighting the hard fight to keep this fraud case that they have going in play. And the Justice Department is actually urging the court to keep this fraud case going. Somebody done slid a judge in who has been questioning a lot of things that's happening with this case, and I'm like, where did the judge come from? So, on April 2nd, in District Court for the Central District of California, Justice Department attorneys argued that a court-appointed special master was incorrect in her recommendation to throw out the lawsuit. She's trying to get rid of it. Like, nah, bye, get rid of it. That's why I said I don't know who they know or not know or whatever, but a whole throw out of a major Justice Department lawsuit. Wow. But anyway, alleging United Health Group overcharged the federal government through Medicare Advantage claims.
Oh, God.
So the case was first filed. So this has been going on for a minute. It was first filed in 2011, and the Justice Department joined the case in 2017. The government alleged that between 2010 and 2017, United Health received $2.1 billion for Medicaid Advantage diagnoses that were not supported by medical records. So, everybody is waiting with bated breath on this to see what the outcome may possibly be. And now this master wants to throw everything out. Okay. Anyway, they claim that the government failed to submit enough evidence to support its case. Somebody didn't proofread the article because I'm seeing all kinds of grammatical. Okay. To support its case are wrong, the Justice Department argued. The United States submitted evidence that United's own coders had reviewed the medical records at issue and did not find support for 1.97 million diagnoses codes.
Wow.
So if your own people said, you know what, y'all right, how you gonna throw it away? I don't understand. So then they give a little history. Medicare Advantage plans are reimbursed by the federal government based on beneficiaries' health risk status. Nearly every major Medicare Advantage plan has been accused of or settled allegations of upcoding or making patients appear sicker than they are to receive higher reimbursements from the government. Medicare Advantage companies brought in $7.5 billion in, quote, questionable, end quote, payments in 2023, according to a 2024 report from HHS's Office of Inspector General. Beckers did reach out to United Health Group for comment and will update this article if more information becomes available. I'm like, well, you got to know somebody for real, to get all of that thrown out.
Especially that amount.
Sir. So everybody going to be watching this. So that was my little church announcement. That was the only one I had.
Well, that's a big one.
That's a big one.
Because I don't know, like the whole risk and I guess because that's how I got started in risk adjustment. Like it seems like so long ago, but I'm like, and it was a mess then. And I'm like, what? It's not as anywhere near as complicated as people make it out to be. Like, oh my God, like I just don't understand it. I really don't.
I think it's the gamification of it. I think they're trying to game it. I think they're really trying to. I think this is my own personal opinion, because to your point, you're right. It's really not that difficult. You look through the medical record, you see whether or not these diagnoses that are listed in here have been assessed within the time frames that you are submitting your information, and voila, you done, right? It could all be so simple, right? However, I think they're following the RAF scores, and they're looking at all of that, and they're trying to see, well, how can we make this, and how can we do this? And so in trying to play that game, instead of just playing the cards you've been dealt, they trying to get more cards out the deck. They trying to do some other things. They trying to flip the whole rules in the game. They trying to play Uno with tongue. They trying to do all kinds of things. And it's like, no, just do what they tell you to do. And because of that, that's why we have all of these issues, in my opinion, I think.
I would agree.
Which is also why I think on the government side, they're reducing and they're cutting they're reducing the things and changing the diagnosis to reduce the score. So now you're going to have to play. It's like every few years, you're going to have to play a different game and trying to figure out something. But when you just would do what you need to do and everybody could get what they needed. Wait a minute, ma'am. Our non-coding correspondent says, I cannot
Dr. Jasmine is hilarious.
Isn't she? I got fired from a risk adjustment job. I kept picking up extra stuff. I wasn't there 3 months. Ma'am, you are the problem. We have found the weakest
link. You need to go work for change. Go work for United Healthcare. They will love you.
They will love you.
Especially with your titles. Look, even Dr. Jasmine agrees with our code.
And she'll be sitting back there like, really? I don't even know what I agreed to. Was it right? No. Oh my goodness. Hilarious.
But the thing that makes risk adjustment such a non-factor is the government even tells you what are the top 10 conditions they're looking for. They tell you. All you got to do is just make sure at least those are right.
At the bare minimum. Like
they tell you. All
be so simple because they break it down to you. Here, do da for these diagnoses. These are the ones that are hot on our list. We keep seeing the same issues. We tell you what we're saying. We tell you what the issues. We tell you how to fix them. We tell you how to avoid them. How much more do they need to tell you?
Exactly. I mean, because there are some conditions that if you go and look it up, they'll say that 75% of the claims have no validation. 75%, that's a lot.
That's a whole lot. A whole lot. And those are just the ones that they caught. That's why they feel like there's so many questionable dollars that are out there from the Medicare Advantage plans. And wow, that's just a mess.
But part of the problem too is what I have noticed because usually risk adjustment coding was very specific.
Mhm.
But now what they have done is they are starting to move to, they started a while ago, and I think that's part of the problem too. They have moved to like full code capture, which that was never risk adjustment.
No.
So when you do full code capture, I think that takes, people have less time, especially with these ridiculous productivity requirements. People have less time to really do a deeper dive and really validate what they found. See, before, when you were only doing risk adjustment codes, like not every condition risk adjusts. So you had time when you found one to really, really dig
Dig into
through
it.
and make
Yeah.
sure.
Yeah.
I think that's also part of the problem that needs to be addressed.
Good insight. I like that. Okay. And your announcement, sir?
Oh, I have a new ICD 10 CM class beginning on Thursday, April 17th at 6 p.m. Eastern Time. To find more information, visit thecodingnurse.com.
Well, that's wonderful. Oh my goodness. All right, all right. Ooh, we have had comedy today. I don't know. I must be
Already.
already. All right. Okay. So for well, let the tea spilling begin. And for those who are just joining us or joining the replay later on, welcome to another episode of the Saturday Morning Tea. We have an important topic to discuss today that affects everyone in healthcare, but especially medical coders, health information professionals, and I believe our compliance and privacy folks can get some of this tea as well. Now, I need to give a disclaimer because all of this is in play at the time of this broadcast. It may be something else on Monday. The way the world is going, it may be something new, something else. I don't know. Folks talking, but as I mentioned at the OHIMA annual meeting, this was a hot topic. There were at least 3 or 4 sessions dedicated specifically to this. And when I tell you, I mean, the people did their presentation, but in a couple of rooms, they kind of stopped the presentation short. Like, let's just get this on the table. Let's talk about it. Let's have an open, I mean, folks was talking. It was off the chain, but I was loving every single minute of it. So anyway, the Department of Health and Human Services, or HHS, the Office of Civil Rights, or OCR, has released a significant update to the Health Insurance Portability and Accountability Act. That's HIPAA. And it's the privacy rule portion of HIPAA. And this was specifically focused on reproductive healthcare privacy. Now, I want to say that this information happened in the previous administration, which could potentially change it on Monday once all the other stuff is addressed, I guess. I don't know. But the final rule was released on April 22nd, 2024. And I know that's a whole year from now, but stay with me. Or a whole year ago, but stay with me. And introduces several important changes to how we handle protected health information, or PHI, related to reproductive health. Again, I know it was released almost a year ago, and the compliance date was actually in December, but there's still a lot of questions and a lot of comments and commentary about this particular topic. So today we're going to break down exactly what this means for you as coding professionals, health information professionals, privacy and compliance professionals alike. We'll cover the background, key definitions, prohibited uses and disclosures, attestation requirements, and updates to the notice of privacy practices. You can find all of this information. I believe I put it in linked into the I'm second guessing myself. I believe I put it there. If I didn't, I'll make sure it gets there. But you can find all of this information directly from the Office of Civil Rights on their website. So we will also make sure that you know all of the important compliance deadlines as well. So this is especially, and Mr. Jesse, you know to jump in, you know how to move. This is especially critical knowledge because as health information professionals, you're often working directly with sensitive reproductive health information. And these new protections will affect documentation, information sharing, and compliance requirements across healthcare settings. So again, brew your favorite cup of tea and let's get started with this information. So background information on this final rule. Again, it came from the Biden-Harris administration through the HHS for Civil Rights. And it's officially called HIPAA Privacy Rule to support reproductive healthcare privacy final rule. So it was like a little separate little thing by itself. This rule modifies the existing HIPAA privacy rule to strengthen privacy protections, specifically for individuals' PHI related to reproductive health care. The requirements were initially proposed in April 2023, and the final version includes several adjustments based on public comments. Remember, they want to get rid of public comments, including comments provided by AHIMA. When we talk about the timeline, there are three important dates to remember. First, the effective date for the final rule was June 25th, 2024. However, the compliance date, meaning when healthcare organizations must actually implement these changes, was December 22nd, 2024. There's still some questions on how to implement, and so some folks are not in compliance and have been very vocal about not being in compliance based on conversations we had a couple weeks ago. And then there's one more date specifically for updating the Notice of Privacy Practices or the NPP. Were you about to say something? I'm sorry.
Mm-mm.
Those updates aren't due until February 16th, 2026, giving providers additional time to comply with that specific requirement. Now, you might be wondering why these changes are happening. Well, the rule comes in response to concerns about potential cross-state legal actions related to reproductive health care following the recent changes in the legal landscape. And the goal is to ensure that patient information related to reproductive health care remains protected, even in this changing environment. So the rule specifically addresses the privacy concerns that might arise when patients receive reproductive health care that is lawful where it's provided, but then potentially not lawful in other jurisdictions. For medical coders and health information professionals, understanding these protections is crucial because you'll need to ensure that appropriate documentation and safeguards are in place when handling reproductive health information. And remember, these requirements apply to all HIPAA-covered entities, including healthcare providers, health plans, healthcare clearinghouses, and their business associates. So regardless of where you work in healthcare, if you are handling PHI, these rules will likely apply to your organization. So let's look at some of the key definitions that are important for understanding how to comply with this final rule. The final rule introduces and clarifies several terms that are central to its implementation. Let's talk about how the rule defines person. Under the rule, a person is defined as a natural person, meaning a human being who is born alive. It can be a trust or estate, partnership, corporation, professional association, or corporation, or other entity, public or private. The OCR clarifies that an individual, child, or victim under HIPAA rules must be a natural person. This definition is important because it establishes who is protected under these provisions and who might be subject to them. Let's also look at reproductive health care. This rule defines it as health care that affects the health of the individual in all matters relating to the reproductive system and its functions and processes. That's real broad, right? And it's intentionally broad and shouldn't be construed to set forth a standard of care or regulate what constitutes clinically appropriate reproductive health care. This gives flexibility to providers and patients to determine what qualifies as reproductive health care in their specific circumstances. So while most people hear and think reproductive health care, they think women. Men have reproductive health care as well. Sometimes they're often a second thought as it relates to being protected or their reproductive health care being protected under this rule. We had a long conversation about that as well. Go ahead.
Because you know what, when I was looking through the documents that you were sent, for this topic, I'm like, you know, what has happened that it's like we've gone backwards. And you have to have all of this language to protect a person's fundamental right to health care.
Mm-hmm.
And like you were, and how you just mentioned men, what I don't understand is like they want to, some states, not all, because some states want to punish a woman for exercising her right to certain reproductive health procedures, but I don't ever hear talk of like, so have they criminalized a man getting a vasectomy?
Right.
Like,
But that's part of men's reproductive health.
right.
Right. So the OCR provides a non-exclusive list of examples of reproductive health care in the final rule. These include, but are not limited to, contraception, including emergency contraception, preconception screening and counseling, management of pregnancy and pregnancy-related conditions, fertility and infertility diagnosis and treatment of conditions affecting the reproductive system, and other care related to the reproductive system. And so it's important to note that the OCR specifically states that either a provider or patient may determine whether received healthcare, such as over-the-counter contraceptives, is reproductive healthcare. This broad interpretation gives significant flexibility in how the term is applied. So for the health information professionals, this means you'll need to be aware that a wide range of services could fall under the umbrella of reproductive health care and therefore be subject to these enhanced privacy protections. The final rule specifically prohibits in terms of using or disclosing protective health care or PHI related to reproductive health care. The core prohibition in this rule restricts the ability of regulated entities to use or disclose PHI for activities with the purpose of investigating or imposing liability on any person for seeking, obtaining, providing, or facilitating reproductive health care that is lawful under the circumstances in which it was provided. It also prohibits using or disclosing PHI to identify any person for such purposes. This is a significant restriction that limits how and when reproductive health information can be shared, even with entities like law enforcement. The rule introduces an important presumption provision. Regulated entities must presume that reproductive health care provided by someone other than themselves was lawful under the circumstances in which it was provided. This presumption can only be overcome in two specific situations: when the regulated entity has actual knowledge that the reproductive health care was not lawful under the specific circumstances in which it was provided, or when the person requesting the PHI supplies factual information that demonstrates a substantial factual basis that the reproductive health care was not lawful under the specific circumstances. It's also worth noting that the prohibition doesn't apply when the PHI is sought to investigate or impose liability on a person for submitting a false claim for reproductive health for payment to the government. That exception ensures that fraud investigations can still proceed. You know, they're going to still look out for their money, right? Additionally, the prohibition from sharing a patient's PHI with law enforcement doesn't apply when the disclosure is to penalize the provision of reproductive health care that is not lawful, as long as the HIPAA Privacy Rule permission applies. So, for health information professionals, this means you'll need to be especially careful when processing requests for reproductive health information, particularly those coming from law enforcement or for legal proceedings. And that's where the stuff was hitting the fan, because it was a mess. Because then folks are asking, well, you need to redact all of this information. So they want the records, but if it's containing information related to that, well, we still need the record. So somebody needs to redact it. And they're like, absolutely not. It's a whole hot mess on both sides of this particular issue as it relates to providing records that are needed. A key aspect of this is that when a regulated entity receives a request for PHI, they must make a reasonable determination about the lawfulness of the reproductive health care in the circumstances in which it was provided. They cannot simply rely on assertions from the person making the request. However, the rule clarifies that regulated entities are not expected to conduct research or perform an analysis of an individual's PHI to determine whether prior reproductive health care was lawful when it was provided by someone other than themselves. For example, a health plan must presume that reproductive health care was lawful unless they have actual knowledge otherwise, or the investigator provides information demonstrating a substantial factual basis to believe the care was not lawful. So this creates an important balance, protecting patient privacy while still allowing for appropriate disclosures when truly necessary and lawful. One of the most significant operational changes in this final rule is this new attestation requirement. So let's break down what this means for healthcare organizations. This rule requires regulated entities to obtain a signed and dated written attestation from any person requesting PHI potentially related to reproductive health care. This attestation must state that the use or disclosure would not be used to investigate or impose liability on individuals, providers, or others who seek, obtain, provide, or facilitate reproductive health care that is lawful, or to identify persons for such activity. This attestation requirement applies specifically to disclosures for health oversight activities, judicial and administrative proceedings, law enforcement purposes, and disclosures about descendants to coroners and medical examiners. The attestation can be collected in either written or electronic format. However, and this is important, a new attestation is required for each use or disclosure request. So you can't rely on a single attestation for multiple disclosures. Regulated entities may rely on an attestation provided to them as long as it is objectively reasonable under the circumstances to believe the statement that the requested disclosure is not for a prohibited purpose. And the rule doesn't require that the regulated entity to investigate the validity of every attestation. However, the use or disclosure of PHI based on a defective attestation does not meet the requirement. So the rule lists several examples of defective attestations. So when the expiration date has passed, when the authorization has not been filled out completely, when the authorization is known to have been revoked, and when any material information in the authorization is known to be false. So to determine whether an attestation is reasonable to rely on, the regulated entity should consider who is requesting the use of disclosure, the permission they're relying on, the information provided to satisfy other conditions, and the PHI requested and its relationship to the stated purpose. And then importantly, a regulated entity is required to cease use or disclosure of PHI if they discover information reasonably showing that the representations in the attestation are materially incorrect. So the attestation must be written in plain language and cannot be combined with any other document. It must include the name of the individual whose PHI is being requested, or the class of individuals if it's not practicable to provide names, confirmation that the use or disclosure is not for a prohibited purpose, a clear statement that the use or disclosure is not for a prohibited purpose, or that the reproductive health care was not lawful, a statement that the attestation is signed with the understanding that knowingly violating it violates HIPAA. The OCR has indicated it will publish a model attestation prior to the compliance date, which it did, that folks still had questions about. And for health information professionals, this means that your organizations will need to develop processes for obtaining, verifying, and storing these attestations when reproductive health information is requested. That's a lot, a whole lot, a whole lot. So most of the people at the conference and discussing this was primarily talking about how their privacy people or how their health information people, particularly release of information folks, really had to be on top of this and really had to stand on business when it comes to law enforcement coming into asking for this information, because they were coming in droves and understanding that I don't care how you come, I don't care what you come with, I don't care if you got you flashing your badge and you flashing your gun, you got to sign this attestation. And based on the information that you put on this attestation will determine whether or not you get anything, period, point blank. Nobody is playing with y'all. And that's kind of where the rubber meets the road, and making sure that health information professionals who are in that release of information role understand how important this is. Gatekeeping at its actually finest. Like, you're the person that is going to be the judge and jury, if you will, on whether or not this information is disclosed. And following the rules is what's going to help you, your organization, and everybody stay compliant with the current rule. Again, it's current today. It may not be on Monday, but the current rule as it stands. Mr. Jesse, did you have to?
It's a lot. It
Mhm.
really is. And and as you were talking, I was thinking back to, people may have forgotten, but this was, I don't even know when, but it was a while ago. I want to say it was Colorado. These these police officers came to the emergency room, and they were trying to force this nurse to draw the patient's blood, who was, I think, unconscious,
Mm,
or the person didn't authorize them to use his blood or
mm,
draw his blood, because they were trying to get him for something.
mm,
And they ended up the police arrested the nurse, and it became a big thing, and the court finally decided that she was right. And when you
mhm.
were saying, like, these release of information people are standing on business, if you don't have people to enforce what is right, then there's no point in having any rules, and people's rights will then be trampled on.
Yep. Yep. You were right about that. All right, let's shift gears a little bit and talk about the required updates to the Notice of Privacy Practices, or NPP. And this affects everybody because we sign them and we give them. The final rule requires providers to update their Notice of Privacy Practices to support both the Reproductive Healthcare Privacy Final Rule and the NPP updates included in the Joint Substance Abuse and Mental Health Services Administration, or SAMHSA, and the OCR final rule on aligning 42 CFR Part 2 and HIPAA that was finalized earlier this year. So there are several key updates required. First, if a covered entity creates or maintains Part 2 records, and these are records related to substance use disorder treatment, They must provide notice to individuals about how those records may be used and disclosed, and about individuals' rights. The MPP must also be updated to reflect other applicable laws that are more stringent than the privacy rule, including details on the attestation requirements we just discussed. Another important addition is a new paragraph explaining to individuals that PHI disclosed pursuant to the privacy rule may be subject to redisclosure and no longer protected by the privacy rule. So for fundraising communications, covered entities must provide individuals with a clear opportunity to opt out before using Part 2 records for fundraising purposes that benefit the covered entity. The good news is that the rule clarifies that notices for both Part 2 and privacy rule requirements may be met with a single notice, as long as all of the required elements are included. So this helps streamline the process somewhat. But remember, while the compliance date was in December 22nd, 2024, covered entities still have until February 16th, 2026 to update their MPPs. This gives you additional time to incorporate these changes. For health information professionals, this means working with your privacy officers and legal teams to ensure that these updates are made correctly and on time. So that was a whole lot. As we wrap up our discussion, let's summarize the key takeaways from the HIPAA Privacy Rule to support reproductive health care privacy final rule. Again, first and foremost, this final rule prohibits covered entities and business associates from, I lost my place, I'm sorry. This final rule prohibits covered entities and business associates from using or disclosing PHI to investigate or impose liability for lawful reproductive health care, or to identify people for such purposes. Second, attestations must be obtained for certain disclosures of reproductive health care information, specifically for health oversight, judicial proceedings, law enforcement, and coroner or medical examiner disclosures. And the model attestation form is already available. You can check it out at the OCR's website. And you can add to it, but they give you the strict language. And most people at the annual meeting just said they used the strict language, that's in the model attestation. Some of them just said, we just copy that and put it on our letterhead and keep it moving, so that we know we're doing what the intent of this final rule is, and complying with the attestation that the OCR is expecting folks to sign. So they we're gonna keep it simple. Just copy this, put it on our letterhead, and keep it moving, or add it electronically. Third, entities must presume reproductive health care was lawful unless they have actual knowledge otherwise, or are provided with substantial factual information demonstrating it wasn't lawful. Fourth, notices of privacy practices must be updated by February 16, 2026 to reflect these changes, as well as the changes from the Part 2 final rule. Fifth, the rule clarifies that covered entities cannot deny an individual personal representative status based on the representative having provided or facilitated reproductive health care. Sixth, HHS is clearly emphasizing privacy protections in a changing legal landscape and trying to ensure patient information remains protected even as state laws vary. And finally, for our health information professionals specifically, understanding these changes is crucial to ensuring proper documentation and to help your organizations maintain compliance with these new regulations. I want to encourage you all to make sure you're reading that information, not only for your organization and making sure that you are compliant as an organization, business associate, all of the things that I listed, but as a patient as well. You need to make sure that you're reading and understanding the information that could or could not be released to others on your behalf. So make sure you're doing that. And then also make sure you're reviewing your policies and procedures and preparing for implementing the attestation requirement. And that's where it was a little sticky with a lot of these organizations, because it was like some folks still have a lot of questions and need some clarification. And until they get that, it's going to be hard to try to put together, well, what is the procedures? If we, if then what? If, and one of the crazy things that we saw, because on the attestation, it asked, I think it was like a yes or no box, like basically, and I'm summing it up, do you plan to use this for legal purposes or something? And one of the people said that somebody checked yes on their box, like, and they were like, oh, what do we do with that? And everybody was shocked, like, well, what do you do with that? And it was like, because they were being honest to let you know, yes, this is the purpose for us obtaining this information. And most people in the rule were like, well, we're not giving that information, we're not giving you anything. But then others were like, well, that's the case where you may have to go and redact information. And they were like, first of all, we don't have the manpower or the staff to sit there and go through volumes and volumes of a person's record to go back to whatever date that they may have done something that may be part of what they're looking at that is subject to reproductive health. Nobody got that kind of time. And so that was when, the volleyball tennis match was happening, because it was going back and forth. I was like, ooh. So that let me know that there's still a lot of questions, still a lot of concerns around this attestation and its requirements. But people, were reaching out and networking, like, well, if you see something, let me know. And you see something, and the person who actually, I think I went to 2 of the 4, were giving out their information, like, hey, because there were attorneys there, people who worked and provided input on the attestation. There were all kinds of folks in the room, and so it was really great to see. And because I don't work in release of information, to some extent, I am well aware of part 2 for dealing with my behavioral health and substance abuse clients and that kind of thing. But this thing was something new. So I'm like, well, I need to know. And I feel like if I don't know, other folks need to know. And so that's why I felt that it was important enough, with so many sessions and so many questions and so many people. I mean, those rooms were filled and the discussion was buzzing. So yes. Wait, I see somebody.
Yeah, that's an interesting comment.
Had a provider tell a friend and a mom what a patient's birth history was and the result of an exam in order to try to bully the patient into a procedure. Wow. That's crazy. Crazy. And so, that's another thing, educating ourselves as healthcare consumers and knowing what our rights are as it relates to healthcare is also very, 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 very important. I know, we may be coming in and we're very vulnerable because we need the help, or we need whatever because we're feeling bad and whatever, but you got to know your rights as well as you're getting that care. Yeah. So this was a lot for the Saturday morning tea today, right?
It was, and it's not even over, because
it's not, because it could change on Monday, like I said, because I'm sure, wait a minute. And then aren't the people at HHS gone? Like, but they might come back, but
it's a lot. It's a lot.
Right. And OCR is part of HHS. So, and I think I read something this morning that said, but they got to bring the people back. So who knows?
But but in the meantime, with all this, fluctuation going on, you have matters like this that are really in limbo, or that can go, the wrong way, because they don't have, it's the right people aren't in the right positions to do the right thing.
Absolutely. Well, I hope all of this information helps you navigate these important changes to HIPAA privacy protections for reproductive health care, and at least gives you some additional food for thought and things to kind of dig into to make sure you and your organization are well aware of what is happening. Mr. Jesse, did you have any other things you want to add to? Look, we might get out of class early.
Yeah, but this was a really heavy topic, and
Uh-huh,
it's important. People, it might not seem important, but it is vitally important
uh-huh, uh-huh,
for everybody.
uh-huh.
And because I'm sitting there thinking, like, as soon as somebody checks a yes that they're going to use it legally, see, at that point, you need a court order. We know
You need
or a
something else.
subpoena. We
Absolutely.
know.
Absolutely. So, you can't come in here with that. And then there are policies and procedures around who and why and how subpoenas are supposed to look and what they're supposed to say. And, oftentimes that
And
varies from state to state. It's a lot of information that needs to be known as it relates to this. So,
and I have a friend who works in medical records for an FQHC,
mhm.
and she goes back and forth all the time with state agencies over subpoenas because they well, in New Jersey, they have to have a wet signature,
Mhm.
like not a stamp.
Right.
And and she said they still try to send it, but she has to. But it's because she's been at her job, so she knows her job. But what about somebody new
No.
who doesn't know that? No, that's not how it goes.
Correct. And making sure that that knowledge transfer isn't lost from person to person to
Mhm.
person coming into those roles. And so, as we've always stated, that's the importance of providing a good orientation and training to the organization, the laws, the policies, the procedures, all of the things, and the role of the new role that the person is taking. They got to know. You can't just be like, okay, well, welcome to the team. Good luck. Fly butterfly. No, you gonna get everybody in trouble.
But
Everybody.
you been and released something and got your facility sued. You don't have no job.
No, nobody will have a job. A whole hot mess. All right. Well, again, I hope this was something that was helpful for you. I know it was kind of lengthy, long, but it's important. It's out there,
Oh, especially now. It's oh
especially now.
God.
Especially now. Well, tune in to next week as we'll be discussing another hot healthcare information topic that you won't want to miss. All right, all right. Let's see. Let me pull up my. Yay, there we go. So, are you thirsty for fresh perspectives on the healthcare revenue cycle? Well, by becoming one of the PRNT sippers, you'll join a community of sharp minds who savor the complexities, like the complexity we just talked about, of the healthcare revenue cycle. Why sip alone when you can steep in knowledge together? Come spill the tea on industry insights. Here's what you can expect as a valued member of the PRNT Sippers: exclusive healthcare insights. Gain access to in depth articles, webinars, and resources covering the latest healthcare trends, compliance updates, and revenue cycle practices. Early access: be the first to receive expert insights and guides, ensuring you stay ahead in the ever evolving healthcare industry. Personalized support: enjoy direct access to our team of experts for guidance on medical coding, compliance issues, and revenue cycle management. We're here to answer your questions and support your professional growth. And community connection: join a private community of healthcare professionals where you can network, share experiences, and collaborate on finding solutions to common challenges. And that's my favorite part. So, by supporting us, we're not only advancing your healthcare knowledge and career, but also contributing to the success of the Professional Reimbursement Network, LLC, which is a resource that empowers healthcare professionals like you to thrive in their roles, goals, and dreams. So, thank you for considering becoming a member of the PRNT Sippers. For the cost of about 2 cups of tea per month, you can join the community. Check out the link in the description of the video, or you can go to bit.ly/the PRNT Sippers. Your support means the world to us, and we look forward to helping you excel in the world of health information and healthcare revenue cycle. All right. Well, thank you all again for joining the Saturday Morning Tea or checking out the replay. Miss Tanika is already on it. She like Mr. Jesse. Was the tea spilled today? Put your teacups in the chat. Put your teacups in the chat. All right. So before we sign off, as always, I have a special request for you amazing viewers out there. If you found this episode helpful, don't keep it to yourself. Share, and share alike. Share the knowledge with your colleagues, especially those that you may know in release of information that may be struggling. And you can do that by hitting the share button. And hey, why not subscribe to our channel while you're at it? That way, you'll never miss a drop of our health information, compliance, revenue cycle, and medical coding tea. And also, if you have thoughts, questions, or experiences that you want to share about today's topic, we would love to hear from you. So drop a comment below and let's keep the conversation brewing. And if you enjoyed this episode, give us a thumbs up because it helps more healthcare professionals find our content. And also check out the Coding Nurse channel on YouTube and thecodingnurse.com, the website. Yes. So remember, at the Saturday Morning Tea, we're all about building a community of savvy, informed healthcare professionals. So again, like, share, subscribe, and comment, and let's grow this community together. Mr. Jesse, do you have any closing thoughts?
No, just keep your ear to the ground because this is right. I just can't believe how healthcare is in such a major state of change right now, and it's not it's I don't it's just I don't know it's just it feels unnecessary
And weird. It feels real weird.
yes
Like, we know we always have change and there's always things in flux, but really, because you want to do something because somebody else did something and now you want to reverse that something and now you got to go back and reverse that. It's like, it's crazy.
it is.
But here we are. What can we do? But keep breathing, Lord willing.
There you go.
And the creek don't rise. Right, everybody. Well, this has been a great session today. See you PRNT sippers at 10:15 a.m. Eastern Standard Time. And remember, be safe, be kind, and don't wish for it, work for it. Until next time, take care and have a great weekend.
Bye-bye.
Bye.